Okay, thank you. First of all, let me express my gratitude to be here in this excellent conference among such distinguished professors and practitioners. And I also wish to thank the leaders of the project for the opportunity to have been involved in this research. Due to my task in this project, my presentation is going to deal with the issue of constitutional adjudication in the examined 8 Central European countries. So constitutional adjudication is a broader concept than the activities of constitutional courts. Although there may be other state bodies that can adjudicate on constitutional matters, in this presentation I am going to review only the tasks and competencies of the constitutional courts in Central Europe. At the same time, by the notion of constitutional adjudication, I mean not only the examination of conformity of legal regulations with constitutional or other normative provisions, for example, international agreements, but also all the other powers that a constitutional court may and typically does exercise, at least in the Central European countries. Constitutional adjudication is also a broader concept than constitutional review. As you can see, employing Sadurski's concept, constitutional review is a system whereby judicial or quasi-judicial bodies can set aside and invalidate the democratically enacted laws on the basis of their alleged inconsistency with constitutional norms. Centralized constitutional courts, however, don't merely review the conformity of norms with the Constitution, but also have a number of other functions which fall within the broader concept of adjudication. It is important to note that all of the examined organs are traditional Kázányian type constitutional courts performing centralized or concentrated constitutional adjudication. So, in the following, I classify the possible powers of constitutional courts regarding this character. According to my own typology, there are 5+1 typical main activities and competencies of concentrated constitutional courts. The first and most common one is the norm control, both in abstract and in concrete manner. The next important task of constitutional courts is the individual protection of fundamental rights, that is the fundamental rights protection, mainly with the competence of the so-called real constitutional complaint. The third type is the power of resolution of conflicts of competence or resolution of jurisdictional disputes. The next one is the adjudication concerning the functioning of the state. For example, deciding on charges against public officers, banning political parties, and so on. And there can be another power, the adjudication on election disputes. And furthermore, +1 function is the interpretation of the Constitution in connection with both all of these tasks and competencies and also as a separate autonomous competence. All of this also indicates that centralized constitutional adjudication is such an activity which is separated both institutionally and functionally from ordinary adjudication. So basically, it cannot be considered as part of judicial system in the classical form of division of power of Montesquieu. The most traditional function of constitutional adjudication as integral part of the Kázányian model is norm control, deciding on the constitutionality of the legislation. Basically, it has two types, the abstract and the concrete norm control. Abstract norm control means that the constitutional court examines the compliance of a norm with the Constitution in a general manner, irrespective of a special case or a special procedure. While in case of concrete norm control, there is an individual case, a special procedure in which the possibility of the unconstitutionality of a law or decree arises. The abstract review may occur either before or after promulgation of the challenge law. The former is the ex ante review or preliminary norm control, and the second one is the ex post review or posterior norm control. So as you can see in this table, as for the preliminary review, first of all, no such power exists in Croatia. Limited such review is available in Slovenia, Slovakia, and the Czech Republic, only in relation to international conventions after their ratification but before their promulgation. Adopted but not yet promulgated statutes can be challenged in Serbia, and the examination of constitutionality or legality of a decision of an autonomous province authority can also be initiated here as ex ante review. Both international treaties and bills of parliament can be contested in Romania, Hungary, and Poland before promulgation. Besides this, the Romanian and the Hungarian constitutional courts can review the constitutionality of the initiatives for the amendment of the constitution. In Hungary, only for the conformity with the procedural provisions of the fundamental law. And in Romania, also mainly in a formal manner, but regarding the eternity clause of the Romanian constitution, a substantive review is possible as well. In the end, the Hungarian Constitutional Court also have the power of preliminary norm control of the standing orders of parliaments. As regards the posterior norm control, in Croatia and the Czech Republic, ex post review can be initiated at the Constitutional Court regarding both the constitutionality of laws and the legality of lower level norms. In Hungary, in addition to the constitutionality review of legislation, it is possible to turn to the Constitutional Court for review of the constitutionality of international treaties and of uniformity decisions of the Curia, of the Supreme Court, as well as for review of the conflict of domestic laws with the international conventions. In Slovakia, Slovenia, Serbia, and Poland, the constitutional courts have similar competencies, except for the uniformity decisions, of course. They can assess the conformity of statutes, central and municipal decrees, and international conventions with the Constitution, and the conformity of statutes and decrees with international conventions. It is interesting that the Serbian Constitutional Court can review the laws in light of generally accepted rules of the international law, and the Slovenian Constitutional Court in light of general principles of international law, besides the international treaties themselves. Primarily, the Serbian practice is based on these principles. In Romania, posterior abstract norm control is narrowly available. The Romanian Constitutional Court can examine the constitutionality of laws and ordinances on the motion of the Ombudsman, the advocate of the people, and the constitutionality of the standing orders of the parliament and other parliamentary resolutions issued on the functioning of the parliament. It is interesting that the only state which regulates actio popularis is Croatia. Any natural or legal person may apply to the Constitutional Court for a declaration that a law or a decree is unconstitutional or that a lower level norm is unlawful. However, the decision to initiate proceedings in this competence is upon the Croatian Constitutional Court, as opposed to the mandatory proceedings on the motion of the public bodies. And this is the difference from the former Hungarian counterpart, where until 2011 any person could lodge a motion for abstract norm control without any legal interest, and the Constitutional Court was obliged to proceed and make a decision on this motion. In the course of concrete norm control, there is always a formal legal procedure, except for the so-called direct complaints, in which the possibility of the unconstitutionality of a norm arises. In case of a judicial initiative, the judicial procedure is pending. In other cases, where the parties to the litigation can initiate the constitutional review, the procedure is already over. Thus, the concrete non-control has two types, the judicial initiative and the concrete non-control on the motion of the concerned persons. In case of judicial initiative, the situation is simple. It is possible in all of the examined Central European countries. It is also a common feature that in most of these countries, the ordinary court must stay its proceedings when it turns to the Constitutional Court. The concrete non-control on the motion of the concerned persons is a kind of constitutional complaint with its original German term, Verfassungsbeschwerde gegen ein Gesetz. In the course of this competence, both natural and legal persons can initiate a specific review of the legal rules. This can be made against such legal provisions which were applied in a proceeding before a court or exceptionally before another public body, that is, against those statutory regulations on which the court's decision or the other public body's decision was based. So in the case of this type of constitutional court competence, the ordinary court proceedings have already ended and there is a final decision in the concrete case. The cause of such a constitutional complaint can be typically the violation of the petitioner's fundamental rights, at least in the studied Central European countries. That is why legal persons have only a limited role in lodging such a complaint. And the typical formal requirement is that the possible legal remedies have to be already exhausted. Almost all of the Central European constitutional courts have such a power, and some of them can examine not only court decisions, but other public decisions as well. In the Czech Republic, lodging a complaint for review of a norm is possible only in connection with the real constitutional complaint, so challenging also the judicial decision itself and not on its own. In Slovakia and Romania, the Constitutional Court has no competence at all for constitutional complaint based on non-control. And besides this, in Slovenia and Hungary, so-called direct complaint is also possible, where the contested norm was applied or became operative directly without any decision of an ordinary court. This can be, for example, pension rules, social security provisions, labor law regulations on employment or dismissal conditions, and so on. Okay, the means of fundamental rights adjudication is the so-called real constitutional complaint. This type of constitutional court competence was developed by the practice of the German Bundesverfassungsgericht, called real or genuine constitutional complaint, in its original German term, Urteilsverfassungsbeschwerde. In this type of complaint, the concerned person can turn to the Constitutional Court if he considers not the legal regulation to be unconstitutional, but the judicial decision itself. So it means that the constitutional problem is about the unconstitutional application of an otherwise constitutional norm. As you can see, in almost all of the examined Central European countries, the constitutional courts have such competence for fundamental rights adjudication, except for Poland and Romania, where there is no such power laid down in the constitution. In Slovakia, concerned persons can lodge a complaint not only against a judicial decision, but against a judicial omission as well. In Croatia and Serbia, there also exists a special institution of real constitutional complaint regarding the protection of judicial independence and judges' personal righs to hold their office. In the end, in Hungary, after 2019, not only natural or private law persons, or as is the case in most of the Central European countries, local governments can file a real constitutional complaint, but in special situations, state bodies and public authorities as well, either if the challenged court decision violated any of their rights guaranteed by the fundamental law, or if such a court decision limited their powers in an unconstitutional manner. Resolution of conflicts of competence or resolution of jurisdictional disputes, just as the power of abstract norm control, is also the integral part of the original Kazanian model of constitutional adjudication. In this power, the Constitutional Court settles the disputes between other public bodies regarding their competence. The conflict of competence can be positive if two or more bodies wish to proceed in a given case or make a decision, and may be negative if no organization wants to resolve a task that derives from the Constitution. In all Central European countries, the constitutional courts have the power to rule on jurisdictional disputes. The power of adjudication regarding the functioning of the state include holding certain public officials accountable and removing them from office. For example, if they have acted unconstitutionally or committed a deliberate criminal offense, and banning political parties if they engage in unconstitutional activities or seek to exercise exclusive power. In almost all examined countries, there is a possibility of impeachment of the president of the state, in which the domestic constitutional court has a role in each jurisdiction. The exceptions are Poland, where this power is exercised by the Tribunal of State, and Romania, where the impeachment procedure is carried out by the High Court of Cassation and Justice. Within this type of power, another frequent competence is the task of monitoring the constitutional functioning of political parties, and of course the possibility of dissolving those parties that operate in an unconstitutional manner. Also, in almost all of the Central European countries, the constitutional courts have such a power, except for Slovakia and Hungary, where the ordinary courts decide on these cases. As regards the adjudication on election disputes, also almost all of the Central European constitutional courts, except for the Polish Constitutional Tribunal, have responsibilities in relation to parliamentary or municipal elections, either in par excellence electoral disputes or in annulment of election results established by electoral bodies. 4 constitutional courts have certain powers regarding referendum disputes or confirming the final results of referenda or overruling other decisions concerning referenda. In the end, in 4 countries, the constitutional courts have also the power to make a decision regarding confirmation of parliamentary mandates. Poland is the only country where the Constitutional Tribunal has no jurisdiction at all to review the verification of parliamentary mandates, nor to proceed in electoral or referendum disputes. As a conclusion, the constitutional courts of the analyzed Central European countries perform very similar functions and consequently exercise very similar powers. The concentrated constitutional courts, as a consequence of the implementation of the Kazanian model, necessarily carry out abstract norm control. With the exception of Croatia, it covers also the possibility of ex ante review, and without exception, some forms of an ex post abstract review, because this latter is the heart of the concept of centralized constitutional adjudication. Actio popularis is, however, is only possible in the Croatian constitutional system. In addition, and in keeping with the European development in constitutional adjudication, concrete non-control is now also part of the essence of constitutional review. Judicial initiative is possible in all the examined countries, while concrete non-control on the motion of the concerned persons is not possible only in 2 countries, Romania and Slovakia, but is an existing and functioning institution in the others. The real constitutional complaint didn't originally form part of the concept of concentrated constitutional adjudication. The original Kazanian model totally lacked this institution, this possibility. However, due to the spreading influence of the German practice, such powers now also exist in most European countries with centralized constitutional courts. This is also true for the vast majority of the Central European countries. Only in Romania and Poland is there no real constitutional complaint. Finally, a further common feature is that all the Central European constitutional courts can act in some of the cases of jurisdictional disputes between such state organs, which typically belong to different branches of division of power. Besides this, the Central European constitutional courts are also empowered to resolve certain situations of extreme danger to public order caused by state bodies within the competence of adjudication regarding the functioning of the state, and in most countries to proceed in electoral jurisdiction, in addition to other very diverse competencies that may be exercised in some of the analyzed Central European countries. Thank you for your attention.